This is JC Setting the Record Straight podcast. I'm your host, JC. On this channel, we set the record straight. That means we fact check and correct commonly believed misinformation and propaganda. So I just want to give a warning. This video is about to be another boring lecture. It's going to be full of legalese, and I'm not expecting people to actually listen to it. This is a response to a video that was recently posted by Coulter, and so I'm doing a response, and I'm going to tag her name. So I would like her to respond to the arguments that I'm about to present. So if you want to listen, you're more than welcome. Otherwise, I'm just hoping to get a response from Coulter. So the video that I'm responding to was a video called My Body, My Choice. So I'm going to play clips, and then I'm going to give my responses.
Hello, welcome to Ann Coulter's Substack. I'm going to be doing a video today on the weather in New York. No, just kidding. This will be on abortion. I don't know if you heard, but the Supreme Court has, quote, overturned Roe, and there is no issue dearer to liberal hearts than abortion. No issue so important. The way they talk about it, you'd think it's a matter of life and death. The reason abortion, there's nothing they lie about more. The reason the Supreme Court is so important to the left is that they can't get Americans to vote for the things they want: abortion, sodomy, gay marriage, cheating on elections. So they tried to win a democracy, but they lose. So they prefer to have philosopher kings on the Supreme Court who will just announce decisions for the whole country, looking at our very limited Constitution.
First, I'm going to correct you on that. We do not live in a democracy. We live under a Republican form of government. It says so right in the Constitution. And there's a big difference between a Republican form of government and a democracy. The founding fathers were against democracy because it would lead to mob rule. So the majority does not get to trample over the rights of the minority. Under a Republican form of government, our elected officials are supposed to protect the rights of the individual. However, they refuse to do so when it comes to controversial issues. They are cowards. They all refuse to support same-sex marriage publicly, but now since the Supreme Court made it the law of the land, now they want to come out and support it. They would not come out in support of abortion until it was made legal by the Supreme Court. And the reason that they keep deferring to the Supreme Court is because the Supreme Court has lifetime appointments. So they can afford to suffer the consequences politically, whereas members of Congress can't. I find it interesting that you would say that Democrats can't get their way through the democratic process. The reality is that Christians can't get their way through proselytism. Since they can't convince the majority of Americans to voluntarily accept their religious dogma, they turn to the political process to force their hypocritical standards of morality on everyone else. When did Jesus turn to Caesar to do his job for him? The fact that Christians have to use the legalized sword to further their sectarian agenda only proves their lack of faith. It proves that they don't actually believe in the power of their plagiarized sun god and that their real faith is in the government. And while we're on the subject of philosopher kings, do you have a problem with these philosopher kings at the state level regulating the practice of law based on their so-called inherent authority? There is nothing in any of these state constitutions which give them the right to regulate the practice of law. Yet, state Supreme Courts continue to promulgate rules which have the same effect as statutes. And these are not just procedural rules, these are substantive rules. I can tell you that I did an open records request to find out who is grading the state bar exams, and then the Supreme Court enacted rules which would prevent me from gaining access to this information, and then the state attorney general applied it retroactively. The judiciary should not have that much power. And if you're really going to get into the issue of philosopher kings, you really need to address Marbury versus Madison. The power of judicial review is also not in the Constitution. Where does it say that the judiciary has the power to say what the law is? This makes the judiciary first among equals. They get the final say on all legal matters. So these are not co-equal branches of government. The judicial branch has elevated itself above all other branches of government, and this is tyranny. Furthermore, most members of Congress and most past, and I believe even Joe Biden is an attorney. So most of them are officers of the court, licensed by the state judiciary, and they have all been indoctrinated to believe that the law is whatever the courts say the law is. And then my final point on this subject is that we did inherit a partial common law system from the British. The British don't even have a written constitution. Their rights are all based on case law. So we have a mixed system which is partly codified and is partly based on case law.
And oh my gosh, here's this right buried here. No one's ever noticed before, but we just found it, as long as a majority of justices say so. So they began politicizing the Supreme Court, back under the Warren Court, I guess, with the proliferation of insane, sudden discoveries of rights or non-rights in the Constitution, no prayer in schools.
So you are correct that it began with the Warren Court, but you need to be more specific. It wasn't Warren who ruined the legal profession. It was Justice Brandeis. By the way, Justice Brandeis should have never even been put on the Supreme Court. Justice Brandeis blackmailed President Wilson into nominating him for a seat on the U.S. Supreme Court. There was some scandal about Woodrow Wilson engaging in some type of extramarital affair. So they threatened to make this information public if he didn't put Brandeis on the Supreme Court. And Brandeis has done so much damage to the legal profession. Brandeis is the one who was going around bragging about how much money he charged his clients. According to Brandeis, the amount of money that clients were willing to pay for his services was an indication of how skilled he was as an attorney. So now we have attorneys going around charging clients $500 an hour, making them take second mortgages on their homes to pay them to put their children through college. These attorneys are shallow as hell. They don't care about their clients. All they care about are their own egos, and this all came from Justice Brandeis. But to get back to your point, Justice Brandeis is the one who concocted the notion of the right to privacy. He wrote about these penumbras which emanate from enumerated rights. He was also trying to create the right to be let alone. For some reason, that right never stuck, but the right to privacy did stick. But Justice Brandeis abused the hell out of that position. In fact, he used his position on the U.S. Supreme Court to get America to support establishing a Jewish state in Palestine. So putting Brandeis on the U.S. Supreme Court was the worst mistake ever.
For example, that's why there were banners, the huge billboards across America, impeach Earl Warren. That's how well things went. If we followed our Constitution in a constitutional republic, Supreme Court nominations would be tepid affairs. No one would care. They're not supposed to be the ones writing the rules. They're supposed to be the ones interpreting the rules.
So you agree that rulemaking is a legislative function. I have never heard you speak against rulemaking by state judiciaries. I really don't see how rulemaking is any different from what was done in Roe v. Wade.
The Constitution provides really not that many rules and not that many rights. One of them is the right to bear arms. One of them is the right to free speech and free assembly. Those are the ones they don't like. No, they like their apocryphal rights like abortion and sodomy and gay marriage and, oh, a million rights for criminals.
Like most attorneys, you have been indoctrinated to believe that our rights are derived from the Constitution. They are not. Our rights come from natural law. The Constitution was just an enumeration of certain rights, but it was not intended to be exhaustive. Although the Ninth Amendment is not taught in law school, nor is it tested on bar exams, and is rarely discussed by attorneys, I'm going to go ahead and read what it says. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it's telling you right there, the people retain their rights under natural law. It specifically says that the Constitution is an enumeration of certain rights. Obviously, the founding fathers could not put all of the rights that were retained by the people in the Constitution, but they put the most important ones. But why is it that the Ninth Amendment is never discussed by attorneys?
So hopefully this is the beginning of the Supreme Court moving in a direction where things are moved back to the states, which is the most freedom promoting concept ever devised by the minds of men. You can live in a state if you want lots of abortions until the last minute, abortions to age 13. You can live in New York or California. But this is why suddenly Supreme Court nominations, particularly when a Republican president nominates someone to the Supreme Court, it is a battle to the death for liberals, literally.
That's why they're called individual rights. Individual rights should not be put to a public vote. That is what a Republican form of government means. And I really need you to explain how leaving up to the states is going to promote freedom. It was the states that supported slavery. It was the states that supported Jim Crow. So this laboratories of democracy argument really hasn't panned out in a way that would actually benefit citizens of individual states. The thing that libertarians seem to miss is that states are far more oppressive than the federal government. Everyone wants to focus on the federal government, limited government at the federal level, but no one wants to talk about limited government at the state level. Who cares about who is elected to be president or put on the Supreme Court or put in Congress? It's the state and local governments which control our taxes, our traffic laws, occupational licenses, our use of private property, including whether or not we can grow vegetables on our own land, whether we can collect rainwater. The state and local governments are far more tyrannical than the federal government. They're the ones who are always harassing us when we're trying to buy groceries, and then some rogue pirate comes and pulls us over to steal our hard-earned money. They don't care about freedom. All they care about is power. And they feel slighted because the federal government has taken that power away from them. And as you can see, most recently, it wasn't the federal government which shut down private businesses. It was the state and local governments. They destroyed local economies. They drove people to financial ruin. I really have no idea what you're talking about when it comes to states promoting freedom. That is not what they do at all. I consider myself to be a noble savage. I know the difference between right and wrong. I don't need states controlling every aspect of my life like I'm a child.
They want their philosopher kings sitting on the Supreme Court and deciding, oh, we like this, we don't like this. And, if you only have 5 people whose minds you have to change by cajolery, by sneering, by Linda Greenhouse articles in the New York Times, that's a lot easier than convincing tens of millions of Americans voting in a particular state. So this is a great freedom promoting decision. As I've said before, all lawyers who are not lying are appalled by the decision in Roe v. Wade, which was already overruled by Casey. So the overruling of Roe was kind of fake to begin with. Even Ruth Bader Ginsburg said it was a faulty decision based on nothing, based on the 14th Amendment protecting the state shall not deprive you of life, liberty, or property without due process of law. That's where they've been getting the right to abortion. The right to kill is the right to life.
Most mammals make life and death decisions on behalf of their offspring as the progenitors. Even gerbils kill their offspring if they are born defective. Again, this is natural law. So the right to kill, as you put it, is the right to life. Now, I agree that Roe v. Wade was a poorly written decision. However, that does not negate the fact that a fetus has no right to exist in someone else's body. States which are attempting to ban abortion are effectively making fetuses squatters in women's bodies. And to the extent that women have a property interest in their own wombs, they should be compensated by the state for the fact that their wombs are now to be used by the state as incubators. So, aside from the fact that Roe v. Wade was not based on good law, the part that they did get correct was that a fetus's life would be protected after viability. Prior to that, the decision is to be made by the mother and her physician. It is her body. So the Dobbs decision was incorrect to the extent that it's saying there is no right to an abortion because prior to Roe v. Wade, this was never recognized under common law. There also was no right for states to regulate a woman's body. That was a private matter. In fact, prior to abortion, the birth control method that was used was infanticide. People were leaving their infants out in the woods to expire. So there is precedent for that. I'm not sure who was making the arguments before the Supreme Court, but they clearly did not bring up any of these issues
in our Constitution. We've also seen some right-wingers saying, now we need Congress to pass a federal law saying there will be no right to abortion, protect human life from Congress. No, settle down, right-wingers. The Constitution does not give the Congress the right to pass a federal law. Now, okay, admittedly, Congress passes a lot of laws that it doesn't have constitutional authority for, but I think we're better off living in freedom under a constitution written by men much smarter than we are.
Okay, but it's still going to require men to interpret the Constitution. Where in the Constitution does it say that states have the authority to regulate a woman's womb? When private citizens file lawsuits against the government for violations of their substantive due process rights under 42 U.S.C. 1983, they actually have to articulate an interest that has been violated, a liberty interest or a property interest. However, the state never has to articulate any interest whatsoever. The state's interest is always assumed. What is the state's interest in protecting the so-called sanctity of life? It seems to me that their interest is in protecting potential tax revenue. States need more citizens to rule over and to take their money. I wish someone would actually force them to admit that so that the state's interest can actually be challenged. As far as I'm concerned, the only person who has legal, moral, or ethical standing to challenge a woman's right to get an abortion would be the father. Everyone else needs to stay out of it. It's none of their damn business. I'm going to refer you back to the Ninth Amendment. And I am aware that the Ninth Amendment wasn't incorporated, but it needs to be. But I also want to refer you to the 10th Amendment. What the 10th Amendment says is the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Why is it that everyone always ignores the part where it says or to the people? Everyone wants to talk about states' rights. There is no such thing as states' rights. States have no rights. Rights are for human beings. Rights were created at the time that the king was sovereign. Rights were created to limit the king's power or to limit the sovereign's power. There are things that are so fundamental to freedom that even the sovereign cannot violate them. Rights belong to individuals. There is no right to rule over other people. States are supposed to protect our rights as they existed under natural law, not infringe on them. States only have duties and responsibilities. They do not have rights. To address your statement about Republicans wanting to ban abortion at the federal level, far be it for me to present arguments which promote statism. However, given that medical doctors are licensed by the state, it could be argued that doctors who perform abortions are state actors. Based on the view that life starts at conception, it could be argued that while acting under color of law, i.e., using their state-issued medical licenses, medical doctors cannot deprive fetuses of life without due process of law. The problem is that fetuses still haven't been born in America, which means they are not citizens and therefore have no legal rights to be balanced against the rights of the mother.
This is a state matter. Again, you can have abortions up until age 13, California and New York. And don't worry, taxpayers will fund it, but maybe not in Mississippi, Utah, Louisiana. I note that some conservatives have taken the CRT position toward abortion. The America is a racist country as their opposition to abortion. I guess the rules are now that we can only criticize policies, whether it's a Supreme Court policy or a state legislative policy, by whether it's good or bad for Black people, whether it comes from a history of racism. I don't know why you can't just say, we don't think you should be allowed to kill other people, even if they're inconvenient.
Abortions are not murder. Abortions are the functional equivalent to taking someone off life support. Just as taking a person off life support is not the cause of a person's death, removing a fetus from a woman's womb is also not the cause of a fetus's death. In both cases, there is a natural cause of death. So, conservatives are saying that there was no precedent for abortion prior to Roe v. Wade. However, there also was no precedent recognizing fetuses as human beings. Where did that come from? Even based on the 14th Amendment, citizenship is contingent upon being born in America. Until you are born, you have no rights independent of your mother. You are not a citizen, and your so-called rights cannot trump the rights of the mother.
But this has become a big thing on the right wing. That's Margaret Sanger, and this is true. She was part of the eugenics movement. And the idea was that defective people should be aborted in the womb. The main focus of that was really not Black people. They were kind of irrelevant, to be honest with you. Yes, Black people would, there were Planned Parenthood clinics sent to Black neighborhoods, but where did eugenics really take off, right-wingers? Think. Germany. They didn't have a large Black population. No, it was white people eugenics was being applied to. It was white defectives. It was white criminals.
Yet, on the flip side, Germans actually paid their women to breed children for the state. America wants to force women to breed children into existence for the benefit of the state without providing these women with any compensation whatsoever.
That was 90% of the eugenics movement. Though, yes, it is true, Planned Parenthood clinics were spread throughout the Black neighborhoods. But can you oppose abortion on grounds other than it's racist?
As I'm sure you are aware, there is something called discriminatory intent, and there is also disparate impact. No one is saying that states are intending to discriminate against black women by banning abortion, but it does in fact have a disparate impact on black women.
I keep hearing this is the first time the court has taken away rights that have been given. Heard of slavery?
Again, it is neither the role of the Constitution nor of the U.S. Supreme Court to grant rights. Their authority comes from us, not the other way around. I'm going to read a quote from Ayn Rand. We are fast approaching the stage of the ultimate inversion, the stage where the government is free to do anything it pleases, while the citizens may act only by permission, which is the stage of the darkest periods of human history, the stage of rule by brute force.
How about one of the most head-spinning reversals was in 1983, the court issued a case named by God, Bowers v. Hardwick, finding that, I think it was Georgia's law against sodomy was constitutional. You didn't have to pass a law against sodomy, but turns out our Constitution doesn't say anything about sodomy. When it doesn't say anything about an issue, as it does about very, very few things, speech, assembly, guns, the right to a jury trial. Actually, that was incorporation by the 14th Amendment. Very few rights are protected by our Constitution. The rest are up to democracy.
Again, this is not a democracy, this is a republic. Furthermore, that is not what the Constitution says. Again, go back and read the Ninth Amendment. What it says is that when the Constitution is silent, those rights are retained by the people. Nowhere does it say that rights which are not enumerated in the Constitution are subject to mob rule.
So Bowers v. Hardwick, yes. Georgia, you have a law against sodomy. I think every single one of the Supreme Court justices said, I think this is a stupid law, but there's nothing preventing you from passing it, Georgia. Georgia overruled it a few years later. It was an anachronistic law, and it was just a trial case that was taken up to the Supreme Court. Yet and still, Supreme Court ruling, states, you want to ban sodomy? Have at it. And about 15 years later, Texas versus Lawrence, they overruled that precedent.
Well, the problem is that states were not enforcing sodomy laws uniformly. Those laws were only being enforced against homosexuals. They were not being enforced against heterosexuals. So if you read the Lawrence v. Texas decision, they created a standard called animus late beer. And the way they describe animus late beer is that it is rational basis with teeth. Those sodomy statutes were born out of malice. Therefore, it is a violation of the Equal Protection Clause. Now, I know they didn't actually decide it based on an Equal Protection Clause. It was based on the right to privacy. But they did indicate that in dicta.
That's what happens with precedents. You can overrule them, which is why I've been particularly enjoying any discussion of abortion on MSNBC. We have to replay all of the conservative justices' statements during their nomination hearings, stating that Roe/Casey is the law of the land. It is precedent. Roe is precedent. It was upheld by Casey. That's double precedent. Yes, it is precedent. Yes, it's precedent. And precedent has now been overturned, as it was in Lawrence versus Texas and any number of other cases, including Dred Scott. Remember that one? Does that ring a bell, liberals?
Actually, what you said is not correct. In fact, the 14th Amendment was created in response to the Dred Scott decision. The U.S. Supreme Court did not overturn Dred Scott of its own volition.
We keep hearing on TV the angry feminist Harridan saying, our daughters won't have the same rights as we will. Well, they'll have one right that they didn't have before, the right to be born.
And therein lies the problem. You conservatives seem to think that you are speaking on behalf of the unborn. You are not. What about the right of the unborn to not have life and death imposed on them? See, some of us anti-natalists, which maybe you can look that up, are not happy about the fact that life was imposed on us. We're not happy that we were forced into this system of oppression. We're not happy about the fact that we have to suffer and ultimately die. Some of us would have been very happy if our mothers had aborted us. Life is not a gift, nor is it a right. It is an imposition. If we're honest about the fact that we are unhappy with having life imposed on us, we will be dismissed as crazy and institutionalized. If states are really protecting one's right to life, why have all states criminalized the right to physician-assisted suicide? If life truly belongs to the individual, that means that the individual should be able to do whatever he or she wants with his or her own life. None of these laboratories of democracy allow citizens to receive medical assistance in terminating their own lives. The fact that states won't even let competent adults terminate their own lives means that protecting the rights of the unborn is a pretext. While anti-choicers can pretend to speak on behalf of those who are not yet born, they certainly do not speak for those of us who are already here. First, they're going to breed us into existence without our consent, and then they're going to force us to stay here. We're going to have to live miserable lives until we die of natural causes and be subjected to their tyranny. They don't really believe in a principle of self-ownership. This is why they have relegated us to blowing out our own brains rather than giving us the dignity that we deserve and the right to a humane death. So you're making assumptions about what the unborn wants when you don't actually know that. It is not for you to decide what is best for someone else's child. If it were up to me, no one would have the right to impose life and death onto other human beings without their consent. But it's not up to me. I have to respect other people's decisions. To give another quote from Ayn Rand said, "He who lives by the legalized sword shall perish by the legalized sword." So to the extent that you want to use the legal system to regulate morality, the same could be done to you in reverse. I could easily make a case that it is immoral to procreate. What are you breeders going to do then? What are you going to do when we start shaming you and start taking away your rights?
So there's that. There are pros and cons. One right taken away, but another one, being born, was just extended to your daughters or future daughters. I think it's worth saying, even though I would be proud to be a member of a party that that not only found Roe v. Wade and Casey intellectually offensive, but also morally offensive. It's been striking to me how the media keeps lying about how this is just totally a Republican versus Democrat issue. I refer you to the state of Louisiana. It was Democrats, they had a trigger law. If Roe v. Wade is overturned, we are banning abortion immediately. This was pushed by a number of Democrats in the Louisiana legislature. In the Senate, of 10 Democrats, 8 voted for it. The 2 who didn't vote for banning abortion in Louisiana, the 2 Democrats who did not support banning abortion, didn't make a fuss about it. The Democratic governor signed it into law. You see, liberals, there are regional differences in America. Why can't you just leave people alone? You don't have Louisianans and Mississippians flying up to New York saying, that's it, no more gay rights parade. We're shutting down the bathhouses. No, they just say, New York's not really for me.
To the extent that we're going to pretend that there are actually two sides, to the extent that we're going to pretend that Democrats and Republicans are actually competing with each other and not working in cahoots against the American people, I would submit that both sides are evil. Both Democrats and Republicans believe that decisions should not be made by individuals, but should be made by the government. Neither party respects us to make our own decisions. In your comment about why won't you just leave us alone? Yes, you should leave us alone. You should let individuals make their own damn decisions.
No, you can't stand the idea that somewhere in America, a baby's life could be saved. Oh, but see, on the Democrat-Republican issue, one of the oddest things I saw today was Representative Tim Ryan, who is running for Senate in Ohio, which is not San Francisco or New York City or Los Angeles. Tim Ryan rushed down to one of the pro-abortion protests and denounced the court's ruling. Biggest government overreach in this country's history. Government-mandated pregnancy. Government-mandated pregnancy. That's like, I don't know, government-mandated AIDS. There are things you have to do to get pregnant, and that's completely still within your realm.
So what? Even if a woman does get pregnant, does that mean that it's no longer her body? What right does the government have to force women to use their bodies to host squatters? The government's overreach is turning fetuses into squatters inside women's wombs. I mean, we're allowed to get fat sucked out of our stomachs. We're allowed to get liposuction. We're allowed to get teeth removed. We're allowed to get ribs removed for cosmetic purposes. If we're allowed to get things removed from our bodies without the government's consent, why is a woman not allowed to remove a glob of goo from her own womb? Even if I were to concede that there is no right to privacy under the Constitution, there still is a right to privacy under HIPAA. How are these bans enforceable at the state level without using women's medical records to criminalize them? How are states actually going to prosecute physicians without violating the patient's right to confidentiality? The problem is that the government cannot throw us all in prison. What is the government going to do when we all engage in civil disobedience? You statists seem to believe that the solution to all of the world's problems is to simply make things illegal. Do you really think that women who are desirous of abortions are actually going to follow this? Do you think that physicians are going to actually stop giving women abortions? It's not going to happen.
Don't have unprotected sex. Yeah, that's just your moderate Democrat. That's what he's going to be trying to convince the voters of Ohio. Hope they will notice that he is not such a moderate Democrat. A big claim being made today, including by the Daily Mail, America's greatest newspaper, but whoops, they got this one wrong, is this insistence that Clarence Thomas said, okay, we're coming for contraception next. That's it, gay marriage, it's gone. Constitutional protection for abortion or for contraception. No, what he said is, again, I have to go back to how lawyers see this case and constitutional law. I remember being so very happy when running into some very smart Harvard Law School lawyers one time, and having them describe the exact sensation I had at law school, and I think all sane people do at law school. I like rules. I like knowing the rules. I really loved the Blue Book, how you do case citations. Just give me the rule and I'll go. I loved federal rules of civil procedure. We got rules. I can follow the rules. And then we all take constitutional law, and suddenly you think you're retarded because none of it makes any sense.
Sorry, but that's not the only thing that doesn't make sense. Bar exams are based on legal opinions. So you can't even get a law license unless you defer to the state proscribed opinions that you are indoctrinated to accept. There is nothing empirical about the law. Somebody made it up. And then on a bar exam, there are two answers that are correct, but one answer is more correct than the other. How is that not subjective? The whole thing is arbitrary. But when you were practicing law, you didn't care. All you cared about was winning your case and racking up billable hours. If the law were as clear-cut as you would like, there would be no need for attorneys or jury trials or judges. It's all arbitrary.
And one of the most beautiful examples is how they got their illegitimate abortion ruling to begin with, just as they use an amendment that says no person shall be deprived of a life without due process of law.
The 14th Amendment is referring to state action. So no one shall be deprived of life without due process of law by the state. It doesn't say anything about private action. It doesn't say that mothers don't retain their inalienable natural right to make life and death decisions on behalf of their offspring. Maybe you should advocate for a law banning gerbils from killing their offspring. Apparently, changing the law is just going to fix everything. That's the prophylactic that we all need. More laws.
And turning that into, a mandate that you're allowed to kill babies in the womb. Similarly, the due process clause, I think English speakers know what process means. There's process and then there's substance. Liberals concocted this idea, substantive due process. Well, no, these are opposites. It's like black and white. There's substance and there's process. So substantive due process is the Supreme Court grabbing onto the due process clause, which again means due process. It means there has to be a hearing. It probably means you have to have both sides able to talk, but basically you have to have a hearing before you can take property or liberty away from Americans. A process. That's not what the underlying rule is. No, they took that and turned it into substantive due process where the Supreme Court gets to announce, well, whatever they want.
As I am sure you are well aware, the original intent was for the 14th Amendment to apply only to black people. The 13th, 14th, and 15th Amendments are collectively referred to as the Civil War Amendments or the Reconstruction Amendments. They were only supposed to apply to black people. So it is a reach for the U.S. Supreme Court to apply the 14th Amendment to all citizens in the first place. And to get into the history about how substantive due process came to the forefront, prior to substantive due process, the right that was protected was the right to contract. That was considered a fundamental right which was subject to strict scrutiny. So I'm going to read what the Contracts Clause says. No state shall pass any law impairing the obligation of contracts. So what that means is laissez-faire capitalism. That means you wouldn't have any occupational licenses, no medical licenses, no law licenses, no regulation of monopolies. The parties to a contract would be free to do whatever they wanted without any interference from the state. And that would include a medical professional's ability to perform abortions. Instead, now they can't because their medical licenses and their livelihoods can be taken away from them by the state. The tyrannical state, which you said promotes freedom. So if the states would stop interfering with the right of private citizens to engage in private contracts, there would be no need for substantive due process. But it was a trade-off. The U.S. Supreme Court gave states more power by relegating the Contracts Clause to rational basis when it was formerly protected by strict scrutiny and replacing it with substantive due process. But I really don't see substantive due process as a serious concern because all of the substantive due process rights are enumerated except for the right to privacy. So really, you need to stop making this about substantive due process and just get straight to the point, and so that everyone can know we're talking about the right to privacy. We're not really talking about substantive due process.
Whatever they want. Oh, suddenly we've discovered a right to fill in the blank of whatever the ACLU just asked for. That's substantive due process. And it was that doctrine that Clarence Thomas beautifully attacked in his concurrence in this case, Dobbs, the abortion case.
Clarence Thomas also indicated that he would support overturning Lawrence v. Texas. In essence, he wants to recriminalize sodomy. He wants to round up gay people and throw us in prison. And you don't think that we should be alarmed at all. We're supposed to just sit back and have faith that everything is going to be okay. The most interesting thing about Clarence Thomas's concurrence is that all he did was cite his own dissenting opinions from previous cases. If you have to cite your own lone wolf opinions, you have a serious problem.
I won't read all of what he has to say, but I'll read a few lines. He says, the resolution of this case is thus straightforward. Because the Due Process Clause does not secure any substantive rights, it does not secure a right to abortion. This is what he is saying, and he, in fact, specifically said what rights have been justified by substantive due process. Well, the ones I mentioned: contraception, sodomy, gay marriage. There's nothing in the Constitution about that. You can either pass a constitutional amendment or maybe, as Clarence Thomas suggests, perhaps those rights are protected by some other provision in the Constitution. Perhaps it is in the Privileges or Immunities Clause. But it's not substantive due process because substantive due process is an oxymoron.
The average American doesn't even have meaningful access to the courts based on the fact that attorneys have granted themselves an unconstitutional monopoly over the practice of law so that they can eliminate free market competition and charge clients $500 an hour. Without the right to counsel of choice, real choice where the license comes from the client and not the state, most Americans don't have any access to counsel. Therefore, procedural due process does nothing to protect the rights of everyday Americans. There are some rights which are so fundamental to freedom that state actors should not be permitted to violate them even if they do provide procedural due process. Dred Scott was provided process, but he was still forced to return to a life of involuntary servitude. To argue that state actors should be permitted to deprive citizens of life, liberty, and property so long as they provide process is absurd. You should be glad that Justice Brandeis was never able to convince the majority to buy into the right to be let alone. If citizens had the right to be let alone, Republicans would really be in trouble. Your mobs would no longer be able to make other people's lives a living hell. Even if substantive due process claims are not legal remedies, they are at the very least equitable remedies.
That is Clarence Thomas's concurrence. But the real point is, besides the constitutional nonsense that has been used to get to these non-constitutional rights, do you really think your state is going to ban contraception? Run for office. Do you really think your state is going to ban sodomy? These were archaic laws that were still on the books, and liberals piloted them to the Supreme Court so they could win a, quote, privacy right.
Whether states would actually ban the right to contraceptives or to engage in sodomy is beside the point. The point is that states shouldn't even have that amount of power. Yes, I do believe that states are going to ban sodomy. They were enforcing sodomy laws up until 2003 when a Lawrence v. Texas case was decided. That is not that long ago. At the end of the day, these are hateful, Bible-thumping idiots. Without pressure from the federal government, states will trample all over our rights.
And once the camel's nose was under the tent, woohoo, we're going crazy. Suddenly there's a right to abortion. As for gay marriage, yes, states did vote on gay marriage. 33 of them voted to reject gay marriage. And then the Supreme Court discovered our precious constitutional right to gay marriage, first conceived in the mind of James Madison.
Okay, so the U.S. Supreme Court protected the right to marry for same-sex couples under the incorrect basis. They got the result right, but they should have done it under a different law. The right to marry should have been protected under the right to contract. But they don't want to use the contract clause because they want the contract clause to be irrelevant. It's going to affect so many other cases. So they want to keep the right to contract limited to rational basis.
Yeah, that's really outrageous. But according to polls, having gay marriage declared a constitutional right has changed people's minds. And now most Americans support gay marriage. So you got a big leg up on that one.
Well, people aren't too bright. They believe that if same-sex couples were allowed to marry, the sun was going to fall from the sky. Earth was going to spin out of orbit, and we were all going to be turned into pillars of salt. Now they can see that the propaganda was nonsense. Now they can see that nothing has really changed. And the same thing applies to abortion. Nothing has changed since women have been allowed to get abortions.
Getting your state legislatures to allow gay marriage, you're not going to get a leg up in the future. You're not going to get nonsense declared a constitutional right just because the editorial page of the New York Times wants it. But nobody involved in the writing of the Constitution ever even conceived of it. Which leads to my almost final point, well, maybe it's my final point on the abortion case today, and that is all of you Republican donors wasting your money by writing multi-million-dollar checks to Tim Scott or various other useless organizations. Could you write your money to get bodyguards for our 6 Supreme Court justices? I have been worried about that all day. I don't think I'm telling liberals anything they haven't already thought of. We know that there was that assassin outside Justice Kavanaugh's home, but all liberals have to do is knock off 1 or 2 of those 6 justices. Biden is president, he replaces them, and they get their philosopher kings back to push through whatever they want in the teeth of how the American people want to vote, particularly state by state, how they are voting.
Well, here's the thing about that. Republicans shouldn't even have a majority in the U.S. Supreme Court. And we have the Democrats to thank for that. First, Justice Scalia died while Obama was still in office. Republicans filibustered Obama's nomination of Merrick Garland. Instead of appointing another nominee, they just rolled with it. And then when the Republicans put up their nominee, the Democrats just accepted it. So that was one seat that should have gone to the Democrats. And then Ruth Bader Ginsburg. She was old and decrepit, having health issues. Rather than retiring while Obama was still in office, she stayed in her seat, and then she died while Trump was in office. So if she had retired, that seat also would have gone to another Democrat. So the fact that the Republicans have a majority is not something that they actually deserve. And now they are wreaking havoc on the American people. Clarence Thomas was the token black guy who never had anything to say. Now all of a sudden he's so vocal. Do we need to remind people about Clarence Thomas and the pubic hair on the can of Coke? I'm going to say I like Clarence Thomas a lot more when he was the token black guy who sat at the back of the bus and didn't say anything. My personal opinion is that Roe v. Wade is not going to change anything. The only thing that's going to happen is that we're going to see a great deal of civil disobedience. Clarence Thomas needs to stick a coat hanger up his asshole so that he can have some empathy for what women have had to go through. Thanks for your support. Be sure to like, comment, and subscribe. Also, don't forget to hit the notification bell so that you will know when I upload new content.